Did somebody?
Okay, good morning and welcome to State Ethics Commission. It's February 18th, 2026, and the time is now 9 o'clock. Can we get a roll call vote? And you are alone, please so indicate.
I'm Commissioner Hong,
Present.
Commissioner Thielen,
Here.
Commissioner Becker,
Here.
Commissioner Gray,
Present.
Chair.
Chair is here, and this is a remarkable event because we have all commissioners in person today for this year. Go ahead.
My name is Executive Director Harris, and I'm present in the conference room. Joining remotely are Compliance Director Chang, Staff Attorneys Neufer, Yamanuha, and Yi, and Computer Specialist Louis. Also joining us is our analyst, Barbara Gash, and our investigator, Jared Elster. Even though this is an in-person meeting, please be aware that all meeting participants are being recorded on the digital record of the Zoom meeting, which will be posted on our website and used to create official minutes. Your continued participation is your implied consent to be part of the public record of this event. If you do not wish to be part of the public record, you should exit this meeting now. For any members of the public who may be joining us remotely, if the Commission's video conference connection is lost during our meeting, we will recess the meeting and reconvene after our connection is restored. Please check the Commission's website, ethics.hawaii.gov, for information about reconnecting to the meeting. If the meeting is continued to a later date or terminated, information about this will be posted on our website. Are there any members of the public joining us who would like to identify themselves at this time?
Judith Wong with League of Women Voters.
Well, welcome. Okay. Before I begin, may I wish all of you a happy new year. Zungi Fa Choi, Sana Faila. That's except to my Chinese, don't ask anymore. And also today is Ash Wednesday, isn't it? Yeah, so again, my greetings to you. But first on the agenda, consideration and approval of the minutes of January 21st, 2026. Are there any corrections by the commission?
Yeah, but just a clarification on page 5.
Okay.
So line 17, the reference to strong performance, I was just referring to the state's ethics code and rules and not necessarily the strong performance in general and conduct of officials.
So would you consider that a correction then, or
Sure.
as opposed to clarification?
Yeah.
Okay, any more corrections? If not, public, are there any comments on the minutes? If not, I'll entertain a motion that the minutes be approved as corrected.
So moved.
Moved by Commissioner Hall,
Second.
seconded by Commissioner Thielen. Discussion? Not roll call.
Commissioner Aye. Commissioner Thielen,
Aye.
Commissioner Becker, Chair.
I was present.
You were present. Sorry, I don't have you on. Apologies. Commissioner Gray, Chair.
And the chair votes aye. No objections, motions carry. Next, proposed meeting date change.
Chair, just respectfully, there was a discussion that some commissioners may not be available at our currently scheduled, and so there's proposal to move the date back by 1 week. So it's just an opportunity to check to see if this works with everybody's schedule.
Any problems with anybody in regards to the date?
That doesn't work for me.
Where are you gonna be?
For work on the
Can you do remote? No. So, well, no.
I could do like later. Like
All right.
Can we do it at 10?
That's fine.
Can we, is it okay, 10 o'clock?
That would be okay.
All right, any objections? We don't need a
Do
motion.
not need a motion.
Okay, any objections? So the next meeting will be on March the 25th at 10 o'clock. Okay, moving along, Deputy Director report.
If I can turn over to Bonita, our compliance director for education and disclosures.
Good morning, commissioners. For financial disclosures update, we are busy preparing for our financial disclosure season. For continuing employees and board members, their deadline is Monday, June 1st, since the 31st lands on a Sunday. So staff will be requesting annual updates from the agency contacts and will be busy processing updates and assisting filers. For new board filers, they will be notified once we get the updates from their board administrators following the end of legislative session. They generally start July 1, so their deadline is August. And because this is an election year, June will be extra busy. June 12th is the deadline for candidates for state elective office. Now, this is the disclosures that are distinct from the campaign spending reports. These are ethics disclosures that are filed with our office if they're individuals running for a state elective office. On the lobbying side, because it's the start of session, we've been busy assisting filers and managing the lobbying disclosures as well. The first report for January, February lobbying activities is due March 31, and then the second half of session, March, April report is due June 1. In terms of e-filing enhancements, our office has now rolled out new system enhancements to the lobbying platform. These updates are mainly designed to streamline the dashboard views with new filters and provide new pop-up alerts to inform users on to make sure that their forms are properly submitted and eliminate any duplicate or erroneous information. So I'd like to thank Patrick and our developers for implementing those improvements that overall will improve the user's experience and increase overall efficiency of the e-filing system. If there are any questions, I'll be glad to answer it.
Commissioners, any questions? The public have any questions? Okay, if not, thank you. Next.
So Enforcement Director Keith Campbell is at the legislature testifying on one of our bills that unfortunately was scheduled at the same time as our hearing. We'll talk about that in a second. But just giving his report briefly, if you look on page 19 of the materials, we have our standard report based on monthly information, which indicates that we had 26 complaints filed in January or reported to us. We had 26 requests for a gift of travel letter or review, and 79 attorney of the day inquiries. Similarly, we closed, and again, this isn't always going to track because it's overall they should track, but in a month activity, we may have more coming in or more closed, just depending on what the activity is. 71 attorney of the days were finished. We did 12 anti-fraud, we closed 30 complaints, and we responded to 23 of the gifts or travel requests. Total of 150 came in, a total of 150 were closed. That just is a happy coincidence. Also, just because it's close to the beginning of the new year, I just would like to also indicate on a quarterly basis, we are doing a broader breakout of the statistics and giving more information based on the origin of what the attorney of the day requests are or what the complaints were involving. So that will again be quarterly. Shifting off the statistics, just would like to also show that on attachment 4, page 20, we do have our annual report, which I'm relatively proud of, and that it really attempts to maybe reduce some of the verbose language that we use and try to be a little bit simpler using more graphs. And we now have more statistics being reported again on an annual basis than we've ever reported before. And we did get some, I think, very positive news coverage as a result of that, just showing the fact that people can kind of see the actual activities that we're doing on a annual basis, and specifically what the points of interest were, including if you look, you can see the attorney of the day trends on page 23. You can see the overall ethics training that we've accomplished on page 24. And then on page 25, you can see, and 26, you can see the ethics complaints and sort of how those are being handled, which I think is really positive information and try to be broken out in a way where it's really easy for people to see and see. We hope next year to build upon this a little bit more, but sort of use this as a standard template on being able to report the information of what we're doing in a hopefully easy to approach manner. That's it. The commissioners or if public have any questions, happy to answer them.
Commissioners, any questions? Yes, Noe.
Comment. I think this is the final, but my name is spelled two different ways on page 51.
We can make sure we address that.
Okay, thank you. And I just wanted to comment on the report, having written a few of these. This is a really nicely done report, so kudos to
Well, I'll take blame for any misspellings, but I do really want to particularly emphasize that a number of staff had their hands intricately involved in putting this together and really want to make sure that they get the credit for, you know, the overall look and feel. In particular, Melissa helped with some of the graphics and really the layout and the design and sort of look and feel. Key and Patrick were heavily involved in preparing a lot of graphics and making sure that's available. So
good job.
thank you.
Yeah, let me echo that too. That was very impressive report. It's not just black and white like a lot of government reports. It reads very well, especially the figures really stand out. So congratulations to the staff. Any comments or any questions by the commissioners? From the audience? No. Okay, next.
If you want to go to the next agenda item,
Okay.
just agenda item number 4.
Discussion on media reports concerning ethics or the Ethics Commission since the last meeting.
So commissioners, this is a standing agenda item, which gives the commission an opportunity to talk about media articles that may have been talking about either ethics or the Hawaii State Ethics Commission specifically. Some of the articles that have popped up in January 21st, there was a Civil Beat column written by Mike Lilly about the Maui Board of Ethics and sort of how they've built up and are doing a lot more than they did now that they have professional staff. There is a Hawaii Free Press article noting that the Judicial Council is looking for applicants for the upcoming 2 vacancies in the Ethics Commission. On February 1st, the Civil Beat had a article about hot bills and mentioned several of our Ethics Commission bills. There were a number of posts about the vacancies. On February 1st, Maui News ran one. On February 4th, the Sunshine blog, the Civil Beat, ran a notice. On February 5th, Hawaii Now ran a notice. And on February 6th, Big Island Now ran a notice. On February 9th, the Star Advertiser had an editorial specifically pushing the bills that we introduced on anti-nepotism and how it would lift up government overall. And there's reference to some of our other bills, including the pre-employment restrictions. On February 9th, also, there was a detailed report on the Star Advertiser by Dan Nakasawa on clean government bills, including the anti-nepotism and prohibition on executive branch high-level officers participating in fundraising, again, one of our bills. On February 12th, there was a reprint in the Garden Island of both of those articles. So the Hawaii got an opportunity to see both the Star Advertiser articles. On February 13th, KPUA had an article on applicants wanted for the Ethics Commission. And then on February 15th was a column that I submitted in the Civil Beat on not weakening financial disclosures for Board of Regents, which was a response to an article written about a week before by Representative Garrett proposing that idea. And I did print out copies, which are in front of you if you want to take a look at them. There's nothing changed them. It's just simply the same article. On February 18th, today, Civil Beat Sunshine blog also notes that there are vacancies for Campaign Spending Commission, are two vacancies, and then notes that there is a vacancy for the Honolulu Ethics Commission's director position. With the retirement of Jan Yamane in December, they're now actively looking for applicants.
Okay. Any questions or comments by the commissioners? How about you? Go ahead.
I like the piece that you wrote, especially paragraph. When a board sits at the crossroads of public money and political influence, transparency becomes even more important. It's a very good statement. Thank you.
Any other comments or questions? How about from the public? Okay. Item number 5, legislative matters.
Commissioners, I very much just sort of want to maybe make this an opportunity for questions. Recognizing that there are a lot of bills and that it could take a great deal of time to go through each and every one of them. The sort of high level view is that all of our bills have either been heard or currently have a scheduled hearing. None of them have necessarily had any significant opposition, at least to date, that we've seen. Some questions and concerns, as is normal, with sort of normal amendments going on. There are a couple bills where I've proposed, I'm not sure necessarily if we necessarily need motions, but I sort of want to give an opportunity for the commissioners to consider the testimony that is being submitted. Specifically on one of our package bills, which expands, this is HB 2106, SB 2246, which expands the scope of persons subject to the public financial disclosure requirements and includes executive directors and includes several new boards and commissions in the public financial disclosure entities. One of the comments that came back is that we had designated a special assistant position in the state library system. And it was pointed out that the special assistant, the job descriptions can be very varied in what they do. And we have always interpreted based on what they do, what their job responsibilities are. So our proposal is to put in a broader catch-all, which is we're going to look at what are the responsibilities, significant fiscal responsibility, administrative oversight, and use that as sort of the litmus test versus what the actual job titles are, and then delete the reference to the special assistant, just recognizing that that job description could change based on whoever is at the library system.
Why don't we do this, since we have all of these bills over here? I'm going to go through each bill. And most of the bill is self-explanatory for the commissioners, so I'm just going to go and ask, do you have any questions or comments about the bill? If not, we'll just move on to the next. That bill that Robert just mentioned is number 2. So let me go back to any questions or comments on the budget bill. Okay, let's go on to the State Ethics Commission. HB 2106 and SB 2246. Any questions or comments? Okay. Public have any questions or comments? Okay, then I'll entertain a motion as in regard to the proposed motion that we recommend to support an amendment removing express reference to the special assistant to the state librarian of the public library system and adding broad language indicating that public filers, regardless of the titles by which they are designated, must file. Is that the motion? Move. Fine. Mr. Becker, is there a second? Second, Mr. Ely. Any discussion?
Sorry, so what does that cover now? The and then
There are express positions listed out in statute that must be public filers. However, those job titles change from time to time. The University of Hawaii in particular is pretty well known for doing reforms and changing job titles. So the broad catch-all is essentially to say that regardless of what the specific title is, if they have these general responsibilities, they'd be subject to the public disclosure requirement. And we are removing expressly one of the amendments we had proposed, which would have named the special assistant, and instead just looking at what the responsibilities are that that person in that position is doing. So if the special assistant position changes in the future where they're not doing something that has significant fiscal, administrative, or other oversight, then they may not have to be a public financial disclosure filer.
Okay, so this is gonna capture a lot more.
The actual intent is it will not. It would essentially be the same job titles as before. But we're gonna look, fundamentally at what they're doing versus at what the title is. So it's essentially a catch-all. So if, for example, right now there's a deputy director, it used to be deputy director at the library system, and that was struck and it became a special assistant position. And so we look at what they're doing versus what the title is.
Okay, only for libraries or for the whole state? Like, I guess.
The general catch-all is written above the list of titles of people's positions, which includes all directors and deputy directors. And the catch-all language would be written above that. So the idea is if one of those positions changed the title name, they would still be caught by the catch-all.
Okay. Any other questions, comments? Ready for the question?
Starting with Commissioner Hall.
Aye.
Commissioner Thielen.
Aye.
Commissioner Becker.
Aye.
Commissioner Gray.
Aye.
Chair.
Chair Growth votes aye, no objections, motion is carried. HB 2107 and Senate Bill 2247 prohibits the executive branch employee who is nominated or appointed by the government to a compensated position, subsequent confirmation by the Senate from engaging in certain campaign funding activities. Any comments or questions by the commission? By the public? Okay, let's move along, unless you have any comments on that.
Very briefly, that is a bill being heard right now, and it's also been scheduled in the House for later this week.
House Bill 2108, Senate Bill 2248 expands the scope of persons who are required to file financial disclosures to include certain gubernatorial nominees subject to Senate confirmation. Makes technical amendments relating to legislators. Any questions or comments by the commissioners?
I'm sorry, could you repeat the bill number?
This is HB 2.
HB 2108, it's on page 5 of your in your file, page 5. Got it?
I must not be looking in the right place. I don't have it.
This is in the agenda itself.
Sorry,
Oh, okay, got it?
go ahead.
Okay. Any questions or comments? How about from the public? Any comments, questions? Okay, moving right along. It's HB 2109 and Senate Bill 2245 prohibits new state employees from taking official action for 2 years on matters that they worked on before state employment. Prohibits former permanent employees of the office of the governor and office of the lieutenant governor from representing persons or businesses for a period of 12 months after termination from state employment. Any questions or comments by the commissioners? How about from the public? Any comments? No. House Bill 2110, Senate Bill 2244, subjects to legislative and judicial employments of the same ethical standards, prohibiting nepotism that are applicable to other state employees. Isn't it the second time we've submitted this?
This is the second year this has been submitted, correct?
All right. Any comments or questions? I hope this time we can get around any objections by, I think correct me if I'm wrong, the Senate doesn't, it approves, but this House gave the negative, basically, that first go around.
Last year, the bill passed out of the Senate. It was heard by one committee in the House and was not heard by the Judiciary Committee in the House.
Do we know what the, what's happening to it, or is it haven't heard, or?
So currently, the Senate heard a different bill that was introduced by some of the senators. It was not our bill. We recommended that they use our language, and that bill is going to come up for a decision making, I think, next week, and I don't foresee any problem with it. The House Labor Management Committee is also hearing their bill, and then assuming it gets through, it would go to the Judiciary in the House. One thing kind of uncertain is the chair of that committee just resigned, so I'm Representative Holt resigned and is now moving to the executive branch. I'm assuming that won't impact the hearing at all, but we will see.
So as it is now, the House committee has not heard it.
Correct, but it is scheduled for hearing.
We were, well, we can hope for the best.
It was scheduled for hearing, as you know, on the day that the state closed down because of a storm. So it's just been deferred. So again, both bills are moving for now. And obviously with the editorial support and sort of the broader public support, you know, hopefully there's a bit more pressure to consider this bill moving forward.
Commissioner Gray, this is one that we're pushing because all of the state employees have this requirement, no nepotism, either hire or supervise. So we thought it's appropriate to have also the legislature to be a, you know, under this umbrella. Well, there was a little pushback by the House, so it's the second time we're pushing this. Hopefully this time we get it through. Especially we talk about the legislature and the judiciary. I mean, you know, we're all in the same, I think, hopefully the same cloth, right? But anyway, we'll see what happens. But thank you. Yes,
Public for comment.
public, any comments from the public? No. Okay, next, let's see. Procurement, House Bill 1885 prohibits state agents from entering a contract to procure or dispose of goods or services or for construction with any business that is owned or operated or in which a controlling interest is held by a relative or household member of a director or deputy director of a principal state department. Any questions or comments on that? I don't know how you can, that's enforcement may be a little tough, I think. But anyway, I'll leave that comment on the
Chair,
table.
if I might suggest, maybe SB 2970 is a identical bill. It
Okay.
may be worthwhile just to flag it and talk about it.
Okay, Senate Bill 2970 prohibits the state agency from entering a contract to procure or dispose of goods or services or for construction with any business that is owned or operated, same verbiage as above, or in the controlling interest is held by a relative or household member of a director or deputy director of a principal state department. GVO, who's GVO?
It's the Government Operations Committee.
Amended per Ethics Commission recommendations and defected the effective date. You want to just explain that before?
Sure. Under the legislative delegation policy, which allows staff to submit testimony, we did submit testimony on this measure, even though it wasn't one of ours, and proposed amendments to it, which are attached in the agenda. And the government operations did adopt those amendment recommendations. Specifically, what those amendments were is to ask that the director, deputy director, or acting director be held accountable for complying with this proposed requirement. And that if there's any enforcement, it would be held against the director, deputy director, or the acting director. So the idea is if they essentially are the ones creating I'm using it as sort of a layperson's perspective, creating the conflict, they're the ones responsible for ensuring that the department doesn't violate it. The ethics code typically applies to individuals, although there are restraints against agencies. Generally, it's an individual's responsibility to follow. So the intent here is to try to follow something similar. This is a bill introduced by Senator McKelvey, and he's the one who's pushing it, and he gladly adopted the amendments and pushing it forward.
Who would have the burden of proof to say that, a relative of a head of the department, therefore is a conflict? Who's gonna police this, I guess, is the better word.
So this would become under the standards of conduct. This would become something that we would be in charge of enforcing. So if there was a complaint, we would be the ones in charge of investigating and potentially holding it, the director, deputy director accountable for it.
So the only way we probably would know if there's a violation is if there's a, hate to use the word whistleblower.
That's true of a lot of our ethics code.
Right.
We don't necessarily have the substantive expertise of what a specific agency is doing or what contract it's entering into. But, this is something that we can build into our training. We can make sure people are aware of it. And I think because there's now going to be some level of public transparency or scrutiny on it, presumptively directors and deputy directors are going to be a lot more cautious about those types of contracts.
I think it's a great idea. Where's Bonita? Bonita, are you here?
She's here.
Oh,
Yes, Chair.
yeah. Okay. If we could build that into our training, I'm gonna give the benefit of the doubt to our government employees that they don't want to violate the ethics code. But, we tell them, hey, you can't do stuff like this. And if you do it, you may be in jeopardy. And so therefore, to me, training is very important. You did a great job. And if you don't tell them, hey, you're not supposed to do this, they can't come back to say, I didn't know. And that's a typical, I didn't know. Nobody told me. Anyway.
We'll be monitoring this bill, and if it passes, normally we update our training modules to reflect any updates in the law. We're also going to be rolling out the new procurement lobbying laws, which take effect January. So there are a lot of changes that are going to be coming on the horizon.
Yeah, well, being on the commission for how many years now, I don't want to hear this excuse, I didn't know, nobody told me, I didn't get that training. I think we hopefully cut that out. Commissioner Gray, you had a question or a comment? Go ahead.
Can you tell me the difference between HB 1885 and SB 2970? Obviously different at this point, but essentially they do the same thing.
They were, I concurrently introduced bills, so they were the same. The judiciary chair basically deferred the House bill pending the Senate bill coming over. And I think colloquially, the idea was if it was Senator McKelvey's bill, he's going to let Senator McKelvey work on it and bring it over to the House. So just because it was deferred in the House, I don't think is a substantive decision.
But the amendment would have been very different.
The amendment now does change SB 2. So, for all intents and purposes, HB 1885 is deferred, and I will use the word dead. It can always come back alive, but essentially dead for now. The SB will be the vehicle moving forward.
And the amendment, was it your amendment in HB 1885 or someone else's?
Well, so it's HB 1885 was deferred, so the amendment was not considered or was not included.
But this is the one that you had proposed.
The SB 2970 is our amendment, and that's what was adopted. And so I've asked, again, under legislative delegation policy, we have a responsibility of letting you know what testimony is submitted and, essentially getting your approval to ratify it. So, we are asking for a motion to support that amendment. And the bill, generally speaking, moving forward, if it does continue moving forward.
Okay,
Thank you.
oh, yeah, you're welcome. Any other questions or comments?
Just technical, but deputy director and director is not always the title of the heads of departments, so. To deal with that.
Yeah.
That's certainly. Do you have any suggestions of how to, I mean, could we say something essentially like regardless of specific title? Or should we try to name each head of each agency?
Yeah, you should call it the head of each. Usually it's called deputy.
Usually aren't the number two guys, some individual, like say guys, are deputies.
Yeah, but the head could be like comptroller or chair.
Oh, I
things
see.
like that. And then I think you're missing like a lot of the attached agencies in this, but maybe this is a start. Still gonna miss a lot.
I think if we can get this one through, then we can amend it later rather than amend it. Or is
But
that-
a lot of like the substantial contracts actually go through the so-called attached agencies.
Good point, good point.
And property development agents.
Okay,
We can certainly suggest that in an amendment as the bill moves forward. So if you want to incorporate that suggestion into the motion, we'd be happy to include that in future testimony.
we did a motion on this. Yes, support SB 2970 and HB 1885. That is our close of motion, you
I
guys.
just have a
Sure.
suggestion, rather than waiting for testimony, what about a letter to the chairs? I think that would be a good idea to do, because that's an important point. You've got the chair of Department of Land and Natural Resources, and you've got the comptroller of DAGs.
The Attorney General, I mean, there's
Yeah,
quite a few actually.
so, but I think that's worth an immediate letter. And testimony following it up.
It will still have to be heard in the Senate by the judiciary, so we certainly could build it into testimony, in the next week or two to the judiciary, as well as notifying Angus McKelvey, who's the chair of the GVO committee and the introducer of this bill, and make sure he supports it.
Yeah,
Is that sufficient?
yeah.
Is that okay with everybody? We'll do it that way. Okay. So how should we propose the motion? Support SB 2970 and HB 1885.
With the proposed amendments discussed.
With the proposed amendments. Discuss, as discussed. Okay. Anybody? I'll entertain a motion. So move Commissioner Hall, second by Commissioner Gray. Any discussion? Yeah, roll call.
Commissioner Hall.
Aye.
Commissioner Thielen.
Aye.
Commissioner Becker. Commissioner Gray.
Aye.
Chair.
Chair votes aye, no objections, motion is carried. All right, anti-nepotism, I gather. Senate Bill 2661 is it? In regards to repeals the language of the state's code of ethics that exempts the legislative and judicial branches from prohibitions against nepotism in public employment. Is that how, question items for the public. How does that relate to HB 2110 and SB 2244?
This is a different bill introduced by Senator Kim, Chang, Hashimoto, Hale Kalole, Gadani, and Moriwaki. It is very similar to our bill, but it has some technical deficiencies, and so we supported it with a suggestion that they adopt the language that we included in our bill, which is still coming up for decision making presumptively. That's what they'll do. So it's just a different vehicle with some language cleanup needed.
And I know that these individuals who really want to push this, but of course, Senate is okay, but the hurdles the House. Is that correct? so far.
based on last year.
Yeah, based on us. Okay, any questions or comments? All right, and the last one is Senate Bill 2778. Or I'll read it, but requires the governor, lieutenant governor, member of the legislature, department heads and their deputies. Again, we're gonna go back to, deputies or number two in charge. And any spouse or dependent child of the governor, lieutenant governor, member of the legislature, or department head and their deputies, second in charge, to place certain financial interests in blind trusts. Prohibits a governor, lieutenant governor, member of the legislative department head and their deputies, or those in second in charge, and any spouse or dependent child of a governor, lieutenant governor, member of the legislature, or department head or their deputies are second in charge from acquiring certain financial interests during the term of service. You want to explain that? That's a lot. That's a mouthful.
It is, and it's not the easiest bill to understand. As we view it, it would essentially require the governor, lieutenant governor, directors, deputy directors, and members of the legislature to have to put any large asset or any asset essentially that they have outside of normal checking and banking accounts into a blind trust. We submitted testimony generally supporting the intent of reducing conflicts or perceived conflicts, but noting that there are a lot of concerns. Blind trusts in and of themselves are a useful tool in certain circumstances, but it doesn't seem like it's something that would have to be applied to everybody in totality. Just briefly, blind trust, for example, if somebody's family owned a large hotel chain and they put it into a blind trust, they can presume that the blind trust isn't going to sell that hotel chain off and that they can still make decisions that benefit that hotel chain, just using that as a hypothetical. So, in some cases, it can be a useful tool, particularly somebody has, stock investments that are traded frequently. Having a blind trust can be helpful to try to reduce the appearance of conflict or an actual conflict with that. But it doesn't seem like it's something that should be applied to everybody as a blind requirement. So we've essentially noted that and said that it would be very difficult to enforce. It doesn't necessarily tie in with our current disclosure requirements or conflict language. I don't foresee this bill moving, quite frankly. I think it's a means for some people to appear very interested, but I don't see it's a pragmatic solution for everybody in totality. We did suggest that if they are interested in pursuing this more broadly, that they can look at trying to expand the conflict of interest language to include legislators. They can, do other steps that may have more pragmatic solution, more pragmatic impact.
Yeah, that's the reason why I wanted Robert to explain it. This is pretty hard. As a matter of fact, take a look at the proposed motion to adopt a position supporting the intent of the measure, but noting certain concerns with implementation enforcement. I guess same thing. And I looked at that. Can you explain for my information, maybe they know, what's a blind trust? Give me an example.
So that is where essentially you put your assets under the control of someone else and you would not have visibility of that trust of what's happening to the assets. So essentially somebody else is administering your assets and you should not have visibility of what happens to that.
You like my son or daughter?
I mean, it could be, you could designate your son or daughter as a trustee.
I'm not going to mention any names.
Does the bill give a really good definition of a blind trust?
It is not the best defined. It says blind trust means a trust agreement where neither the trustee nor the beneficiaries have any control or influence over or knowledge of the assets in the trust, which complies to the definition of a qualified blind trust and it references a federal definition. So that's fine, but I think the actual administrative, it would go in effect right away, requiring over 100 people to immediately implement this would be challenging.
Are there any other jurisdictions that use this definition or this model?
I'm not aware of any other jurisdiction that has this strong of a requirement.
Did any of the trust businesses testify?
No, not that I'm aware of.
Okay, good questions. Any other comments or questions?
I was just going to go, Robert, in your testimony about, alternative or complementary policy approaches. What would you flesh that out?
Sorry, what page are you on? Just if I can quickly get there.
I'm on,
44.
44 and the last paragraph, top sentence of it.
Thank you. So I did reference expanding the existing conflicts of interest provisions to public officials or legislators in this
No.
case.
Where that the legislature may wish to consider whether alternative or complementary policy approaches could address the underlying concerns. What are you suggesting there?
Sure. So the second sentence says, for example, broader refinement of existing conflict of interest provisions, enhance transparency with current financial disclosures, or doing more random audits essentially of actual financial considerations. So these are some of the things that you could do that would address some of the same concerns, but maybe be less onerous for the individuals.
I'm just going back to think of my time in the legislature. When I first was elected, I happened to have a small amount of Hawaiian Electric, which I immediately sold because I just saw that as a big conflict. But there were a lot of legislators that kept it and very ferociously defended that decision. How do you get into maybe having a category of assets that where the entity does business with the state?
So there are a lot of great suggestions. Divestment is certainly one option. What we wrote here was the conflict of interest. So if that applied to legislators, which it currently doesn't, legislators would be required to recuse themselves on matters.
They never did.
Well, again, our conflict of interest law does not apply. They have their own conflict of interest language, and our section does not apply to them for that. And so that's one suggestion, is you apply the state conflict of interest language to legislators. And that would be one easier to apply option.
I think the blind trust could prevent some people from even participating in government. I don't think that's the best way to go at it.
So we added the language, if you look on page 45, if the bill moves forward, ... it may have a potential impact on the willingness of qualified individuals to serve in public positions. And that is certainly a flag. It's a pretty onerous requirement.
Oh, yes. Any other comments or questions? A little levity. Aren't you glad you sold your Hawaiian Electric stock?
That was like 40 years ago.
Oh.
35.
Okay.
They were sailing high.
Anyway, any other questions or comments? Again, the motion that is recommended is adopt a position supporting the intent of the measure, but noting concerns with the implementations. Some like self-policing, if you ask me, but again, that's the motion that you.
Could we maybe look at maybe not supporting blind trusts? I don't like the ramifications of that, because I think we do lose a lot of very qualified, good people when they would be told that would be a requirement.
Would you want to strengthen the testimony that's already been submitted to oppose the measure?
To oppose blind trust, but support a more whatever ethical approach.
So in other words, if I can understand it, you wanna, you don't object to adopting a position supporting the intent of the measure.
Yeah.
Without reference to any blind trust,
But opposing blind trust.
but opposing blind trust.
That's the whole point of this bill.
I know.
Yeah, I know, that's,
I
yeah.
think the intent really hasn't come through the bill, which is to really address conflicts of interest with assets held by legislators. And I think if you could address it that way
Sure.
and indicate, maybe, I'm not sure that I've used the word oppose, but indicate the difficulty that the state would face in general, the public would face in general. If we went that way, as opposed to simply extending the conflicts of interest law to the legislators themselves. I'm feeling uncomfortable with the blind trust. Because I think it goes beyond the issue, which is simply, if you have a conflict of interest, state it. And recuse yourself.
Well, let me break this down. First of all, is any objection by any of the commissioners that we adopt a position supporting the intent of the measure?
I think that can get confused.
All right, that's what I'm thinking.
Yeah.
And because the second part was, okay, you're fit for it, but you're really against part of it. So that's my question is, how do you want to approach this? We can just say oppose it if you want.
We can do it, if you don't mind. The testimony can be drafted in such a way where it says we support the intent of addressing financial conflicts of interest.
Yes.
More broadly, however, we have strong reservation concerns about the broad applicability of blind trust, the way this bill proposes it, and really dive into the concerns about blind trust.
And how would you put that into a motion?
So again, we can support the intent of the bill specifically.
I'm gonna put you on the spot. I'm gonna take a 2-minute, 3-minute break, or write it out, and then we'll see if we can do it today. Is that okay?
Can I ask?
Sure.
Why are we trying to get involved with that argument? We support minimizing conflicts of interest, but to delve into like why this bill is problematic doesn't seem like our issue. Shouldn't the governor's office or the people that employ these individuals be the ones testifying as to why this is problematic?
This would radically change the state code of ethics. It does not integrate with our current financial disclosure requirements, our conflict of interest requirements. I mean, it would be a big change of what we do, and we would be the ones in charge of enforcing or resolving it. So we would be the ones having to interpret what is a blind trust. And so it's squarely our issue, I think. And clearly, if there was a strong legislative policy where they really, really wanted to do this and they passed the law, we would try to make it work, right? But I think it's our obligation to express the concerns with it, specifically implementation, if nothing else.
I think there's also, along with that, a budget argument. That is, at this point in time, this would require a significant increase in operational costs.
So going back, are we all in favor of saying something? I guess that's a better word.
You just say we have concerns about this. Yeah, comments, just submit comments. Yeah. And
As opposed to taking a position.
yeah. Yeah.
That is what we have submitted already. We did submit comments and we noted concerns, and we can make that language sharper. So the motion, if it's okay, move to support the intent of minimizing financial conflicts of interest, but express concerns with the application of a blind trust.
Commissioner Becker?
Okay, I mean, I just think sometimes when you put support the intent, even if you word it carefully,
Well, what's your recommendation?
I mean, I think on the bill itself, it's just comments. So,
So technically, support goes to, I support the bill as it stands, comments is neither support nor oppose. And then there's opposition.
if you put support the intent, it'll be read off as support.
So currently sorry, this is, if you look at the regarding testimony commenting, so it is submitted to legislature as a comment. It is not submitted as a support. And I think the idea is to recognize that efforts to reduce financial conflicts of interest are good. This isn't the way to do it, and to write it in a way where it's clear to say that.
Well,
But we can even strike the support the intent if you wish.
How about
Simply
this?
say we're expressing-
Adopt a position recognizing the intent of the measure as support. And noting the concerns with the implementation. So eliminate the word support. We recognize. So is that okay with folks? I mean, that's basically,
Okay.
huh?
Yeah, it's
All right,
good.
I mean, we're already submitted
I
something.
mean, it's kind of like,
It doesn't matter, yeah,
the
yeah,
wording matters.
yeah.
So we've also used the word appreciates. Positive feedback.
I had a hard time filing my financial disclosure. My wife got on, never mind. Okay, yeah, but is that okay?
Sounds
Yeah,
great.
use the word recognize as opposed to support the intent of the measure, noting concerns with implementation, or what do you have?
Application, but implementation words too.
But let's do a downer on the trust.
Okay, I'm stick that, wait a minute, go ahead and read it off, I'm sorry.
So it's a motion recognizing the intent of minimizing financial conflicts of interest, but have concerns with the application of a blind trust. Again,
Of
this is a
the
motion.
application, I don't think that does it,
Implementation,
but how about, but no concerns about the, an implementation of blind, or a requirement for blind trusts.
Give him time to write it out.
Why do we limit to blind trust, just implementation of this proposal?
We could do that too.
I don't know if anybody wants to go down this road, but. I think. Speaking of
Concerns about the-
agency, you might want to throw in the word strong concerns. Simply because of the cost and the difficulty of implementing such a blind trust, as opposed to. This is the right way to go, the wrong way to go. There's a significant cost.
But Commissioner Thielen wants to emphasize no blind trust.
Yeah,
Yes.
Okay, so if nobody has any heartburn with that, we can stick that in there and then. What else?
Right.
Well, let her finish.
he's doing a lot of writing.
Okay. Wait for this. Oh, I can't. You read it.
motion to recognize the intent of minimizing financial conflicts, but have strong concerns with the requirement of a blind trust.
All right, I'll entertain that motion. Moved by Commissioner Thielen, is there a second? Second by Commissioner Gray. Any more discussion? If not, roll call.
Commissioner Hall,
Aye.
Commissioner Thielen,
I,
Commissioner Becker, Commissioner Gray, Chair.
Chair votes aye, no objections, motion's carried. Thank you, commissioners, for the great discussion. I believe we're on item number 6, and I think it's called adjournment. Is that correct? Adjournment. All right, move that we adjourn. It is now 10 o'clock. And is it okay if we take 5 minutes? And then,
do we have to vote on the adjournment?
yes. You want to? All right.
Do you have a second?
Is there a second? Okay. Actually, we don't need a.
You just do it.
Yeah. Any objection to adjourning? Okay. No, wait, it's, the meeting is so adjourned. Are we off today? Are we off?
Thank you, everyone.
You have to announce when we're coming back.
Yeah, we're coming back.
Oh, you have to announce.